I want to let you know that the handout that you have here is also available on the web, and so if you mislay it or there aren't enough copies or you want to refer to it later, it's Hijabs SCT for Supreme Court. You can get these materials and handy click-through links on the web if you want to see the oral arguments or some of the underlying cases that are associated with this area of the law, and also some of the significant history in the case study that we're going to talk about today. So we have lots of valuable resources. I urge folks from that customized link to click to your heart's delight. Here's our roadmap for today. Like every important oral advocate, I want to tell you where you're going, and then hopefully we'll actually get there along the way. We'll discuss some of the general overview of the legal protections for religious practices in the workplace. We're going to explore the key concepts in that around a key case, the Abercrombie and Fitch case, which was handed down by the U.S. Supreme Court on Monday. And also, importantly, because the legal ethics rules implore us to try and integrate ethical teachings wherever we can into the coursework, we're going to touch upon the rules of the Board of Judicial Standards, which are, I think, especially relevant and important to the judges and court staff that are here with us today. So, let's begin. I'm going to start at the very, very, very top. The key source for all of what we're going to be talking about today is, of course, the First Amendment. And within the Bill of Rights, it's at the very top of the Bill of Rights as well. Congress shall make no law either respecting an establishment of religion or prohibiting the free exercise thereof. Okay? So we have important religious liberty guarantees in the first part of the First Amendment, and also in the first part of the Constitution. I start here for a couple of reasons. One is I want to make the idea clear that the protections for religious exercise in the workplace and elsewhere in public society is not a peripheral topic to America. It is at the very core. It is at the very top. It is exceedingly important. We start the First Amendment with these ideas. This is who we are as a people, okay, and who immigrants to this country become when they adopt the ideas around Americans. That we are a nation founded and grounded in the ideas of religious liberty and personal journeys of conscience, and those receive protections in our law. In fact, we start out in the Bill of Rights with those protections. Moreover, because these protections are drawn from the Constitution, they cut through all of the other subsidiary statutes and regulations and policies and circulars and bulletins and practices because of the Supremacy Clause. Okay? So not only is it at the top of our constitutional order, but being as part of the constitutional order, it cuts through all of the others. The other idea that I wanted to get across is that the converse is also true. As we'll see in a couple of slides to come, this is the first link in a series of links, a series of chains across our federal law. It starts with the Constitution but doesn't end there. There are federal statutes and federal regulatory provisions that form a single unbroken chain in our law providing these protections. So the headwaters can be thought of as the First Amendment of the Constitution, but they run throughout and they run deep. As Meghan Trainor might have said in a different context, every inch of you is beautiful from the bottom to the top. And so you need to think about that piece when you think about these protections. Title VII, maybe not the most artful bit of drafting in the federal code, but certainly amongst its most comprehensive. Very, very broad protections for religious liberty and religious exercise codified in the statutory law in Title VII. It's unlawful to discriminate on the basis of religion in hiring or discharge, or to discriminate as to the conditions of employment due to religion. Or you can't limit the employment opportunities or affect the status as an employee due to religion or religious practice. These are broad, overlapping, pyramiding, complementary sets of protections. To my mind, they signal that the drafters of these particular provisions were trying to reach every employer-employee relationship from coast to coast in a truly nationwide program, and really to leave nothing out. To prove, or at least to try and establish that point, that Congress was sending a management memo to every manager, this means you. Try this thought experiment. Try to think of an employer-employee relationship that does not relate to hiring, discharge, compensation, terms, conditions, classifications, opportunity, or status of employment. If you can think of some feature of the employer-employee relationship that doesn't involve one of those, you've got one on me, I'll buy you lunch. But I think that the shorthand proposition, again, Congress to local employers, public and private, wherever they might be in this great country, this means you. Okay? Religious practice is if it needs to an accommodation, is going to be favored, and there's going to be an important balancing, which we'll turn to now. What do we mean by religious practice? It's theistic moral beliefs or ethical beliefs, or non-theistic moral beliefs. You don't necessarily have to believe in a supernatural creator in order to have protections for religious belief. Rather, it just has to be as to a system as to what is right and wrong, and that's sincerely held, and held with a like intensity or valence that we would hold traditional religious views. Okay? So you don't need to believe in the supernatural. They just need to guide your sense of right and wrong, and held in a fashion that is similar to other kinds of beliefs that are held by those folks who are religious. The strength of the belief is more important than the framework, or its cosmological features, or even whether it's broadly held by other folks. You can have genuine minority positions and still have it as a sincerely held religious belief. You don't have to have a large church. You don't have to have bricks and mortar at all in order to receive protections. So again, this is a very broad concept, again, as inviting as one could possibly be, and I think deliberately so, for a country that is founded upon genuine religious liberty. You don't need a big group. You don't necessarily have to believe the same kinds of things that I believe, or in the way that I believe. How do we know this? There's a definition in Title VII, 42 U.S.C. 2000E, subpart J. There's an implementing regulation at 29 CFR 1605.1, and similarly, the U.S. Supreme Court and United States versus Seeger all point to these kinds of things. So you don't have to take my word for it. Importantly, the EEOC, the Equal Opportunity Employment Commission, has gone on to define specific kinds of practices, and also that accommodating these kinds of practices by employers is not, I think in the EEOC's view, a particularly big deal for employers. They've done a detailed survey. They went out and studied the landscape and to try and learn about the kinds of religious accommodations that were sought and kinds that were routinely given and withheld as well, and came up with a series of findings which they promulgated in their regulations. And they concluded the practices which are routinely not being accommodated include Sabbath observance, the need for prayer breaks during work hours, following certain dietary restrictions. I shouldn't have to eat pork along with the other folks at the company barbecue or whatever. Time off during a mourning period after the death of a relative, prohibitions on medical examinations, and the focus of our talk today, as I have to keep on, religious dress and grooming habits following particular religious observance in the workplace. Okay? So the EEOC contended that not only were these types of important religious observances not being honored when sought for accommodations on a disturbingly routine basis, so they concluded, but they also concluded, and I think important for our analysis today, is that there was little evidence of any unfavorable impacts to the employers by accommodating these kinds of things. Allowing Lipman to wear a kippah at work, not such a big deal to your enterprise. Not a huge impact to you. You can work around that. Okay? And that is important when we think about the balancing of the employer's needs against the needs of the employee and the society's needs to have a place that is open and welcoming to religious diversity and religious practice. What do we mean by undue hardship? With regret, and I'm just going to spend a brief moment on here because we have other items to talk about, is undue hardship is the same words are used also in the ADA, and I think to considerable regulatory confusion. It is a very different sense of undue hardship in the context of Title VII than it is under the Americans with Disabilities Act. Under Title VII, it's a more forgiving standard, which is there a substantial impact? Should the employer accommodate in this kind of situations? Is it really going to have a meaningful disruptive impact on your enterprise if Fred gets off on Saturday for Shabbat observances or whatever, or off during Ramadan or whatever, to observe the mourning period of the death of a family member? Is that going to impact your enterprise? With the ADA, it's a much stricter sense of undue hardship. Are there resources in the entity and in the enterprise to put in the ramp, to make the doors a certain width? Okay, and so in Title VII, in a shorthand, colloquial way, should you accommodate is the balance of equities in that appropriate. And in the ADA context, undue burden, I think, means could you? You know, will the company go bankrupt or not have sufficient cash flow in order to make this kind of accommodation? Very, very different set of balancing of the equities, and a much less forgiving, and I think appropriately so, in the context of accommodating disabled people. In the context of the ADA. With regret, I wish Congress had picked other terms because there's considerable confusion about the cross-pollination of using ADA cases in this other context. Very different standard, I think, intended, and that's in the case law. What does undue hardship mean? I think a good shorthand would be safety first. We have a gal here who is wearing a hijab, and a gentleman here who might, for religious reasons, have long hair. In the 2008-2009 period, there were cases brought by the EEOC in two different contexts. One for the Department of Corrections in the state of New York, where it had a no headgear policy in the prison system, which include hijabs, include Sikh turbans, include kippas, include any kind of head covering, because the Department of Corrections was concerned about the introduction of contraband, or, as you might imagine in the case of a hijab here that goes under the neck, that could be a safety risk if an offender grabbed a corrections officer wearing a hijab, and had clothing that was around the neck. Okay, and so they had a legitimate and serious safety concern. And the EEOC agreed to a consent order that said they would do an individualized assessment based upon the particular job that worker was doing in the prison system and whether or not it indeed, in fact, caused a hardship in order to accommodate. I think there are a couple of propositions to bring from that. One is that there needs to be an individualized inquiry about whether this really does have an impact. And frankly, if the EEOC is willing to take on the state of New York Department of Corrections, they have lawyers to sue you. Okay, there isn't any bigger entity, I think, than the state of New York Department of Corrections, and they didn't blink an eye. And so again, when this means you, this also means they have the resources to come after you. And so I think it's important for all employers to take these kinds of admonitions seriously, because, like I said, I think if you're willing to sue them, you're willing to sue anybody. Okay, so they're quite serious about it. Similarly, in the long hair case, Grand Central Partnership had a rule against long hair length amongst its sanitation workers, the people who cleaned 30 Rock and the NBC headquarters in Rockefeller Center. And they said, well, what gives? Why can't you have long hair in this kind of circumstance? It was, well, we're concerned about some of the cleaning equipment that we run and we operate, and that the worker would get caught. And so we want you to tie up the hair or manage the hair in such a way that there isn't worker injury. And again, the EEOC said, okay, well, we'll look at a worker-by-worker, job duty-by-job duty type of assessment because you have a legitimate safety reason for your workplace rule. It's not either intended to burden particular religions in any particular way. So I think safety is an important prism to think about not only undue hardship and what it means, but also where there might well be a balancing of the particular interests. Let's talk about our case. Abercrombie & Fitch is a retail clothing company that operates stores across the United States under a variety of brands, including Abercrombie & Fitch, Abercrombie Kids, and Hollister. Abercrombie, at the time that the case started some years ago, required employees in its stores to comply with what it called a look policy. That policy is intended to promote and showcase the Abercrombie brand amongst its sales associates, which it terms sales models, to model their clothing, and to exemplify the classic East Coast collegiate style of clothing. Regrettably, Abercrombie & Fitch doesn't have a big and tall, but we can wait. Notably, the policy prohibits employees from wearing black clothing and caps of any kind, so I'm doubly foreclosed by the look policy. Abercrombie instructs its store managers not to assume any facts about prospective employees in job interviews, a very good practice, and not to inquire about aspects of the applicant's religion for obvious reasons. You don't want to have a disparate impact claim that you're singling out particular types of folks. Samantha Eloff, seen here, is a practicing Muslim, and in mid-2008, Ms. Eloff, then 17 years old, applied for a sales position at the Abercrombie Kids store in the Woodland Hills Mall in Tulsa, Oklahoma. Ms. Eloff met with assistant manager Heather Cook, also seen here, to interview for a sales model position. Ms. Cook did not know that of Ms. Eloff's religion, but she assumed, because of lots of other reasons that were in the record we can talk about, she assumed that she was a Muslim and figured that there was a religious reason why she wore the headscarf that she wore every time she saw her, and indeed in the interview. In the interview, Ms. Cook detailed the requirements of the look policy, and Ms. Cook did not ask Ms. Eloff about wearing the hijab or a headscarf, and Ms. Eloff did not offer a reason why she did. Okay? So there wasn't any exchange on either side, and these pieces will become important later. Ms. Cook liked Samantha, and for reasons we'll talk about right, I think correctly so, wanted to hire her, and so made a call up the chain of command to Randall Johnson, her district manager. Mr. Johnson said that Ms. Eloff should not be hired because she wore a headscarf, a clothing item that was inconsistent with the look policy. No head coverings, sorry. Downgrade her application, not hire her. When Ms. Eloff learned from a friend that her application was downgraded because she was wearing a head covering, she filed a complaint with the EEOC. So, Samantha, why do you want to work at Abercrombie & Fitch? I imagine that kind of interview going. Tell me. She had good answers, but with regret, it didn't work out. Interestingly enough, the parties fought over who had superior knowledge in this kind of case. Whose burden was it to bring up the fact that this head covering was inconsistent with the look policy? Ms. Eloff and her team in the EEOC said, hey, you know what your brand objectives are, Abercrombie. You know what kind of market reach you're trying to market position you're trying to reach. You know what market you're going after. You know the specifics of your policy. You know the needs of your brand and your stores. You're the best person, best entity to figure out areas where you can compromise. You knew. Miss Cook didn't have any doubt. She figured correctly. She guessed right. And Abercrombie & Fitch returned and said, wait. Samantha has a duty to raise this topic because she knows things that are way more important to this inquiry. She knows how religious she is, what's going to matter to the practice of her faith. She knows what requirements are. You know, not every Muslim observes the same tenet and observes the same practice. I don't know if she's Audrey Hepburn or not. She could just be wearing the Breakfast at Tiffany's scarf. Who knows? We have no idea, and she didn't offer anything. And we certainly don't want to treat heard differently by inquiring about these types of things that we don't ask other applicants that come in without any kind of head covering. She would know if there's better areas of compromise. This is a duty better left with her. And in fact, if you look at the regulation, 29 CFR 1605.2 says, after a prospective employee notifies the employer of his or her need for a religious accommodation, the employer has an obligation to reasonably accommodate. The reg says it's her duty. I think there are a couple of double-edged swords here, and why this case is so difficult. If Abercrombie was under a duty based upon to act upon its suspicions, and Heather did in fact suspect, and suspected correctly, does that not subject certain candidates to inquiries that it doesn't make of others? Is that a disparate impact claim? We're only, no, you dress a certain way, we're going to ask you these questions that we don't ask about, are you available to work on Tuesday afternoons? Can you lift 10 pounds? That we ask everybody. We ask, certain questions if you dress a certain way. Well, that's going to be a genuine problem. Or if there's certain different scoring criteria. We're in really deep weeds if we do that, says Abercrombie. And in fact, in what I thought was a very artful but ultimately unavailing, and I'll give you a little bit of the spoiler there, ultimately unavailable bit of briefing, they said EEOC wants us to engage in a totality of the stereotypes test. I don't know if she's a Muslim, but I kind of got a thing, and so I'm going to ask. Isn't that acting on bigotry? That is what they argued. And I think it's a point we're thinking about. If Samantha has a duty to act, and this is where I think it gets really, really, really hard, isn't she disadvantaged in the hiring process? Because she has to do two things at once. I want the job, and I also want you to change your policy. And I think as a practical matter, as we think and grapple about what this case means, that's the rub. That was a step too far for the Supreme Court, as we will find out. But there's a step ahead. I get ahead of myself. The 10th Circuit said notice was the key. It was, Ms. Eloff won a $20,000 judgment in front of the district court after a trial. It went up onto the 10th Circuit. The 10th Circuit reversed and entered summary judgment that they didn't get before for Abercrombie and Fitch. Okay? And they said notice was the key. Ms. Abercrombie never informed Abercrombie prior to its hiring decision that she wore the headscarf for religious reasons, that she wasn't Audrey Hepburn, and that she was going to continue wearing it as part of her faith, as an expression of modesty. She doesn't show her hair to men that are outside her family. It just isn't done. And because she didn't say so, Abercrombie wins. It can't assume. It shouldn't assume. There's a circuit split on that piece, and certiorari is granted. The justices really struggle with how to have the right interview question that, because I think they really hated Abercrombie's practices. Heather knew, or she really strongly suspected she was right. This system, without a good reason, impacts Muslims disparately and unfairly, and it's just awful, and we don't want to be a part of it. And so they struggle with how do we get to the right interview questions. And in ways, I think, regrettably, that make this Supreme Court look like a federal and nationwide interview board drafting question. We're going to put together the right Title VII question for you that every employer can ask. And I'm not sure that's the best role for the court, but they were in oral argument. You can listen to the transcript. They were really into this. So, asked Justice Sotomayor, why can't the employer just simply say, we have a look policy that doesn't permit beards. Can you comply with that policy? The reply to that question was, well, it doesn't reflect the employer's obligation to accommodate. We're putting all of this on the employer. Okay, so that doesn't work. So then Justice Alito, goes in and goes, okay, well, couldn't the employer just say we have a policy, no beards, or whatever? Do you have any problem with that? Why do you have to say, does it have to be phrased, could you do it? Could you just say, do you have a problem with that? So again, they're busy drafting, like lawyers, the right interview question that every employer can use. And I'm just not sure that I share with you my view here, that that's not the best in the traditions of the High Court. But clearly they were troubled by the equities of this particular decision. of an employer sitting back who had a strong and indeed correct suspicion about the need for accommodation and just said, no, I'm not going to do it. Didn't say. The Supreme Court decides 7-1-1, okay, so 7 justices in the majority, in a majority opinion written by Justice Scalia, with Justice Alito concurring and Justice Thomas the lone dissenter. Okay, so I think that this lineup is kind of interesting in the sense that these are 3 conservatives, the 3 of the conservative justices fighting amongst themselves. Okay, ordinarily one wouldn't usually split apart Scalia, Alito, or at least and Thomas many times, but here I think it's an interesting split up. And let's spend some time, because I am actually, maybe I talked too fast. We do have a moment here. I want to spend some time on this opinion because I think it's really very interesting. Justice Scalia says, an employer who has an actual knowledge of the need for an accommodation does not violate Title VII by refusing to hire an applicant if avoiding the accommodation is not its motive. Okay, I just want to spend some time thinking about that hypothetical. Heather says, we're delighted to give you accommodation, but I'm going to make you ask, and ask nicely. You're going to have to beg. I'm not going to say anything. I'm glad to give it to you, but you got to ask. Is this such an employer? I mean, well, one, is it, horribly sadistic, like to orient your business that way, but I don't think there are employers like that just say, we're delighted to do this, but you got to ask pretty please. So I think that at some level, that's a red herring. It might be a correct statement of the law, but I don't think that that such employers exist. The second part, I think, is more frequently an example, but it's more problematic. Conversely, an employer who acts with the motives of avoiding accommodation, and in the High Court's view, that was Abercrombie and Fitch. We don't want to deviate from the look policy. We like the look policy, nothing on your head. Don't care. That they might violate Title VII whenever it has no more than an unsubstantiated suspicion that an accommodation would be needed. Heather knew, she didn't get confirmation, but she knew, and that's enough. And in fact, Justice Scalia writes, that's enough. You can have a disparate treatment claim that she was treated unfairly if you have an unsubstantiated suspicion. I think that that's problematic because the High Court hints but does not go into how an unsubstantiated suspicion equals notice. I think that would have been because the regulation talks about notice. And I think also likewise problematic, although I'm glad that this is widely regarded as a victory for religious liberty and protections for head coverings in the workplace, something I strongly favor. I worry that a disputed issue of material fact on an unsubstantiated suspicion. The employer suspected because of the way that I acted in the interview. I didn't say anything, but it's easy to get to a disputed issue of material fact on that, and I don't think we have a genuine regulatory standard. And I think that if you have a Title VII claim, it's easy to get to a jury on this because the standard is frankly so low. Now, maybe that's as a policy matter a good thing, but I think that it's a rule that isn't very clear, I think, to employers as far as its instruction, and leads to lots of litigation or the extension of litigation in ways that I think it's worth at least thinking about. It might not necessarily be desirable. That's sort of where Justice Alito says, it's like, hey, I think there's enough in this record. Heather knew, she admits she knew, or she suspected, she didn't say she knew. Heather suspected, she had good reason, there were lots of facts in there that gave bona fides to that. I don't think it was appropriate for the 10th Circuit to enter summary judgment. They should have gone to a jury, they should have gone to trial. Okay? Now send it back. You don't get a summary judgment on this piece. Okay? And that's where Justice Alito ended up. Justice Thomas says, wait, we have to talk about the difference between a disparate treatment claim on the one hand and a disparate impact claim on the other. Disparate treatment is Heather knows she's a Muslim, we're not going to give accommodations to Muslims, we don't want them working here. We're treating Muslims differently as applicants because we don't want them part of our enterprise. Disparate treatment, we're treating them differently. Disparate impact is we have a headscarf policy that says nothing on your head. It impacts Jews and Muslims differently than other folks. It's a disparate impact. And Justice Thomas, I think with some force, says, Samantha, however loathsome Abercrombie was in this particular circumstance, was treated just like every other applicant. No, nothing on your head. And equal treatment, as shabby as equal treatment is not disparate treatment. And I think that there's some force to that. And the reason why that is significant is because there are some bits of relief that are available in disparate treatment. Congress particularly authorizes money damages in disparate treatment. It doesn't like folks who intentionally single out minority groups and says you're not part of the enterprise. That's not what Americans do. So we have special damages for them. It might just be other kinds of lesser forms of relief if you're doing something that just hammers religious minorities. We don't want you to do that, but there's a different sense of the culpability there. And he says, you know, they did something, they just didn't do what you pled. This is not a disparate treatment claim. At best, it is a disparate impact claim, and that's not what the lawsuit was about. Okay. So really very difficult pieces going on here, even though I think, in my judgment, I'm glad, as the AP reported, that the gal wearing the hijab won. Okay, now, I think there's more to it, and that's why I'm so glad that you showed up for this CLE, because I think that there's a lot more to it than that story, and something to think about the kind of workplaces that we have. But, like any great Hollywood story, it has an alternate ending. A great ending, as a matter of fact, and one that I think is the one that Hollywood would have preferred, and not a 7-1-1 decision, although that has some nice pictures too. The day after that Samantha was turned down for a job at Abercrombie Kids, she did get a job in the Woodland Hills Mall, same mall in Tulsa, at Old Navy. And because they were eager and willing to hire her and recognize how good that Samantha would be for their brand, I just want to let you know that this summer when I'm on the bench, under my black robe, I'm wearing pastel-colored capri pants on sale for $28 while supplies last. This is an important stand for religious liberty, not just a fashion statement. And so, maybe I'm over the line here, but I guess I want you to think about your own look policy, which would be to look beyond Abercrombie and perhaps to Old Navy as a stand for religious liberty, because they did the right thing. They hired Samantha and were very happy with her service. In fact, there are two alternate endings. This is just like Harry Potter. You can pick the one on the special features that you like the best. The other ending is that after 7 years with Old Navy and working her way up to assistant manager of the Woodland Hills Mall, when the Brookside Mall opened up and Urban Outfitters was looking for a merchandise manager responsible for their entire inventory, they hired a very stylishly dressed, great for the brand, hip and haute couture, Samantha Eloff, to supervise all of the purchasing of their entire inventory and to open up their new Brookside Mall store, seen here. And there is I think a joyful, promoted, recognized Samantha Eloff 2 weeks before her case was argued in February before the Supreme Court. So this, I think, is a better ending in a way. The market recognizes, I think, in a clearer, better way that our imperfect system of applying the case record to the facts and the law arrives us at. And I think, no doubt, she will be as a great success for Urban Outfitters and its brand in Oklahoma as she was for Old Navy. I think there are some implications for us. As I said at the top of the hour, the CLE authorities are interested in having us reflect on every occasion just like this about our ethical obligations. And so I want to bring that down to our own role as officers of the court, as court employees, as members of a tribunal, There are very broad workplace protections under federal law that operate on us and for us through the Supremacy Clause. And I think it's also, I will argue to you, part of our ethical obligation that the Supreme Court has all officers of the court, all those who take the oath on obtaining a license, to act in a certain way that is consistent with those federal obligations that protect workplace observance of religious practice. We are obliged as judges, and I'll get to the others in a second, but as judges, not to manifest bias or prejudice in our work. Moreover, as we get to the bottom, we shall not permit court staff, court officials, or others subject to our direction and control to do so. So when we think about the tribunal as a workplace, and there are lots of dedicated folks who make our court system run, everyone from the person at the counter to the person signing the order, this ethical rule means us. It means that we need to be thinking about accommodating religious preference and religious practice in a meaningful way. Otherwise, in my view, I think we are at risk, if not in fact doing, that we're manifesting bias and prejudice by unreasonably not accommodating those religious practices and giving life to the protections that exist in law and to our American ethos. So when I said earlier in the drafting that this means you, I think the Supreme Court put an exclamation point on that. This does in fact mean you. So now we're here to our rearview mirror. I think if you look at Title VII and the underlying parts in 1605, 29 CFR 1605, there are broad protections for religious practice in our law. They're pyramiding, and I think that they are drafted in a way that is as comprehensive as they could be. I think that breadth suggests that all employers need to be a part of this conversation, and they need to be engaging in a productive, respectful, and inclusive way with the people who are part of their teams. I'll also footnote that I think it's good to have that kind of diversity in your workplace because it makes not only the work life more interesting and vibrant, I think it makes our civic life, and for those folks who are here in government service, makes our civic life more interesting and vibrant. And you are opened up to a world of ideas and a world of experience that you're not, that is foreclosed to you if everyone at your job where you spend 8 or more hours a day is exactly like you. Also, importantly, the Code of Judicial Conduct prescribes religious bias in the courthouse. It puts an affirmative obligation not to manifest bias or prejudice and includes everybody who is subject to the direction and control of the tribunal. And so this is really very serious and important, and it's the right thing to do. I think the keys to that is a respectful dialogue and genuine discernment. Those are the keys to success. You want to engage prospective employees about their needs for accommodation in an open, inclusive ways, believing, because it's true, as Congress believes, that your workplace will be better off with that kind of inclusiveness. It is, in fact, the right and beneficial thing to do. And with respect and genuine discernment, I think that that's the way to get out of and avoid legal troubles. And I think, not to put too fine a point on it, given the resources of the EEOC and I think their regulatory vigor, that's not an insubstantial thing to think about. And it's a drag for employers to get caught in that kind of situation, particularly if they have their own brand concerns. Think about what I've just said about Abercrombie & Fitch for the last hour. That's not really very good for them. And frankly, I think the Urban Outfitters has benefited mightily, not only in Tulsa, but elsewhere. I'm sure that all sorts of folks came to the store eager to buy, decorated records or whatever, prints that they wouldn't have otherwise buy because, like my capri pants, they were eager to make a stand for religious liberty, to vote with their dollars for Urban Outfitters once they knew that she was there. Very good for their bottom line to do the right thing. And so with that, I have a very good bit of news. You've earned an hour of elimination of bias CLE credit. We're going to have a short bit of conversation. I know that we have some time, but I wanted to sweeten you up a bit. That 205, 719 are among the most delightful numbers that you'll get this week, that you've earned an hour of credit, and rightfully so. And so with that, I'm glad to engage in any kind of dialogue, rebuttal, attacks, questions, things you want to explore some more. I know that, particularly because I was eager to get it all in, I rushed a little bit at the beginning. What do you think about this? Is Abercrombie correctly decided? Oh, Madam Librarian, please, let's start at the top.
I know that you have followed this case very closely. Was it decided in the way that you anticipated?
I will admit to you, I had no idea how this would come. I did listen to the oral argument several times. I mean, I think it is really very interesting. I think it stands for the proposition that hard facts make bad law. I'm myself troubled by, I think in my own private view, that Justice Thomas is right, that this was not the claim that EEOC pled. Something bad happened to Samantha. I don't think it was disparate treatment. I think it was disparate impact. I think she was not, they had a neutral rule that was applied to her and meant something different to her because of her faith. And I think that is different. And frankly, I think that there is some force to the idea that if the regulation, I'm an administrative lawyer, this is what I do. If the agency interprets the statute, goes through notice and comment rulemaking and says the employee must notify, must provide notice, and it's doubtful as to whether, particularly where, at least it's an open question, because Samantha didn't say, I need this because of my faith, that the case didn't come out the right way because the reg says something else. Now, whether the regulation itself as a policy matter should be more in line with the ultimate view of the case, I probably wouldn't disagree. I think we should be as open and inclusive. But I think that the particular and difficult and hard facts make this case problematic. And the result, it's very unclear to employers what they should do and what an unsubstantiated suspicion means without engaging in bigotry or stereotypes. So I think that those things have real force, even though, like I say, I express some satisfaction, with the AP headline, girl with hijab wins at Supreme Court. Yay! I was excited about it. Okay, that's the right person at some level was vindicated. I worry about as a lawyer, as somebody who, as a regulatory lawyer, somebody who can, is deeply every day concerned about what the application of the words of a regulation mean, whether this comports with all of that. And frankly, I think that the Justice Scalia opinion, and this may seem immodest in the extreme, makes a hash of it. I don't think it is clear instruction. Now, on the other end of it, people get busy. They've got bigger fish to fry. It's June. There's lots of huge things coming out. Maybe this one, isn't so important. Please, yeah. Counselor.
Judge, you began this discussion with the First Amendment, and the First Amendment, of course, only applies to the government. But Justice Scalia, infamously to some and famously to others, wrote a case called Smith, where they interpreted the First Amendment to only apply to a disparate treatment type of claim, not a disparate impact claim, because it is viewed as if the government has a neutral rule applied to everyone and there's no untoward motive against a religion, then it's constitutional. Here, is it surprising that he doesn't join Justice Thomas in saying, well, of course, Title VII allows for different treatment. Congress had different reasons than apparently the Congress did. for the First Amendment. And so what you should have done is done a disparate impact claim, but instead you read it as a disparate treatment claim, basically doing what you couldn't do under the First Amendment. Is there some tension there?
There is a tension. I refer to it as a hash. I completely agree with your analysis, and that they jumble it all together. This case, I think, was complicated enough. Certainly if you look back, and I invite folks to look at the briefing, there's a petition for certiorari in the briefs associated with that, I believe, in the handout that's linked. And I think explaining to the High Court that doesn't necessarily work in Title VII in this area all the time, the difference between those two sets of claims, and they're very different. I think that they've been conflated, not only because of the facts of this case, but I think in ways because it was rushed, and I think that the genuine unease about the kinds of things that Abercrombie was going to do, and if you, I think, maybe mechanically to some, faithfully to others, sort of follow what the regulations said, or ordinary statutory interpretations, it gets you to a genuinely icky and awful result. And I don't know, maybe I'm being too much of the legal realist, but I think that there was considerable discomfiture about endorsing the kind of things that Abercrombie was doing, and when it had a reason to know, and it should have been more open. A proposition as to which I don't think anyone would disagree. I hope that that's an answer, Councilor. I think that there has been a conflation there and a confusion, and I think we're all for it. Please.
Did Justice Scalia's opinion respond to Justice Thomas's in any way?
I'm trying to think of places where it's most notable. My sense of it is that, and again, it was a very brief writing, that Justice Scalia said that because the purpose that Congress had in mind was to attack these kinds of motives, which is to avoid giving an accommodation where you really think it's appropriate. Samantha said, can we have a little give on the look policy here? She's great. No, sorry, no headscarves. I think Justice Scalia in the Ferris reading was what Congress was aiming at. Now, I think if you, I hate to be out textualizing Judge Scalia, if you take the words of the statute and the words of the regulation, that wasn't what was pled, in my view, by the EEOC, and it was only late in the game, very late, that they sort of had this different theory about disparate treatment as opposed to disparate impact. Justice Lillian.
Well, I just wanted to take some small issue with your characterization of the tension between the federal constitutional standard and what you find in Title VII. It's true that in Oregon Department versus Smith dealt with laws of general application, unlike Minnesota under Article 1, Section 16, where we've got a stricter interpretation of religious liberty. But that doesn't mean Congress can't legislate something beyond what's constitutionally required with regards to freedom of religion, and that looks to be what they did in Title VII.
Oh, no, I didn't mean to imply otherwise. I think it's part of an integrated chain, is what I was trying to say. That it starts with the pristine headwaters of the Bill of Rights, but flows out. And indeed, I think, given the enforcement powers under the 14th Amendment, you could constitutionally pass all manner of these types of protections. They're in our best traditions, and I think with the proper delegations, the regulations can further definitize and make that even more nimble.
And a follow-up question, is it your view that the protections of Title VII with respect to religion are pretty much the same as the Minnesota Human Rights Act, or do we afford more or less protection?
I don't believe sexual orientation would be part of.
I mean, with regards to religion.
Oh, with regards to religion. So the question is, Minnesota Human Rights Act. I don't know. I haven't actually thought of the question. I think it's an interesting one about whether our state law adds adjuncts on that are different. I think frequently the claims are pled together. If you're here, and I'm not aware of an instance where one was sought but not the other. And again, I think my sense is because under certain claims under Title VII you can get fees, but there's a magnet there on your choice of form. Not saying that these aren't matters of sound discernment by learned counsel, but if somebody else can pay the fees, I think that's a draw, and that has an impact as well. Judge Cervantes, please.
Yeah, Judge, could you elaborate on what the holding was in Hijabs?
The holding is that an unsubstantiated suspicion was enough in this particular circumstance, that an accommodation was needed to assert and to survive summary judgment on a disparate treatment claim. So under facts like this, if there was a good reason because of the totality of the circumstances around it, that you can get to a jury because the employer had a good reason to suspect that an accommodation was needed and not rendered because of a motive not to render an accommodation. Man, that's a drag. Jeez, we want our head covering policy, and again, the defense was she didn't say anything. We're delighted to give, but she didn't say anything. No notice. And so I think the holding is no. This is enough. And so many commentators say, well, this is a narrow holding because there might not be that many circumstances where you kind of have a good idea because of the surrounding circumstances, and that this is actually not very broad. My view is that an unsubstantiated suspicion and a disputed issue of material fact on that is an open door, I think, to trial, and that there won't be any speed bump as far as a summary judgment. And the benefit, maybe, I'm not saying that that's necessarily an anti-plaintiff sort of view. I don't think that there is any compensation on the other side of a sort of limiting principle about what notice means. Maybe if there were a trade like these kinds of facts lead you to an unsubstantiated suspicion, but we're silent as to that. And so we have the open door to trial, but no way for Abercrombie, I think, in a meaningful way without engaging in stereotyping or racial profiling, to train on, what would give you a rise that an accommodation might be needed. I don't know how you write the employee manual about that. And again, I'm not shopping at Abercrombie. I'm still mad. Okay, so this is not an ode to them, but I'm thinking about employers in good faith trying to train around this, and there are shoals on either side. You don't want to engage or inspire engaging in stereotypes, and yet you also want to be open to the religious accommodation. Now maybe it is beyond the pay grade of the justices to say, well, we really can't worry about that. I think there's not much to that argument, given that they were willing, I think, to be the interview board and draft the question. There was 10 minutes of oral argument about, can you say this, or maybe say that, or, and so I think they were trying there to articulate a principle, and so maybe it's I don't in my own course I don't mean to leave people with an unsatisfactory. Ending. I like my other alternate ending. Go to the DVD special features. The alternate ending is much happier, I think, than the situation that we're left in, which is that Samantha is merchandise manager of Urban Outfitters. We have a question from the web.
The online question is, wasn't the decision that employers should not consider the candidate's religion in making a decision?
Indeed, I think that's the general instruction, and from the manual, and drawn precisely from the EEOC guidance material, which is, that the features of an applicant's religion are not relevant. They really shouldn't be. And yet, I think that if you have a suspicion that it might need to be accommodated, these are tight spaces between those two principles. and getting clear guidance. And again, for a nationwide program of all sorts of different kinds of employers, again, I think that one of the premises I started with is that Congress wanted a broad application that would apply to everybody. Those shoals, that sort of narrowing of the waters, I think is difficult and problematic, and something that we'll need to work through together as persons of faith and persons not of faith. I have one last advertisement. If you like what you heard today, I'd like you to consider two other things. We have an even better course. I'm booked for a double header on Wednesday, June 24th. It's a webinar only. There are only 95 spots. I want you to be a part of that. So if you would like to enroll with our state law librarian, we have the U.S. courts and the war on terror, all sorts of interesting sovereign immunity issues, long-arm jurisdiction issues, statute of limitations issues, tort issues of the U.S. courts giving compensation to American victims of overseas terror. Really interesting stuff. As timely as this, because as we consider in these days of reauthorizing the Patriot Act, the Anti-Terrorism Act of 1991 authorized a significant role for the federal courts in compensating American victims of terror in the wake of the Achille Lauro incident. Congress was really mad and passed this statute. In February of this year, a set of 41 American plaintiffs got a $218 million judgment that under the federal law could be tripled to $640 million. And I have the trial exhibits, and you will too. You'll see it down to the pay stubs. But only if you enroll in the webinar. You won't want to miss it. Other than that, you can follow me on Twitter. I'd love to see you again. Thanks so much for your time. I'm very grateful.